All right, guys, welcome to the webinar for the insurance tech that we are doing now with an accelerated automation. We have Eric Troutman here with Troutman Amin, and we're really excited to be able to talk to you guys about the TCPA laws. Now, this is our second meeting. Our first meeting was a hit webinar that I failed to record, right? But that led to a great opportunity to come down here, meet Eric in person, who has been so gracious to have me down, and we've already been able to cover so many great things, and also gave us an opportunity to kind of hit a little bit of a different format for this particular meeting, really a little bit more specific and drilling down into Q&A that's specifically going to apply to insurance agency owners and what you guys are doing every day in your offices, and how some of the things that you're doing today might be just fine and you can continue, and other things that you might want to look at adjusting to make sure that you are compliant. So Eric is the czar of the TCPA. He is literally where you go if you want the hard facts and you want to know exactly how you should be operating your business to make sure you don't have to worry about the FCC or potential lawsuits. Of course, any lawsuit can be named, but we want to make sure that it is a groundless lawsuit, and that is why you would come to Eric. So thank you so much again for more of your time.
Absolutely, Mariah. It is wonderful to be hanging out with you. She's the nicest person. You guys know this. You're watching. She's so much fun. I really enjoy talking to you. And I have to admit, our last webinar was great. It really is too bad that it lives on only in the memories of the attendees and nobody else and nowhere else. But
yeah.
This one, I think, hopefully we'll be able to record. We'll find out.
Yeah, well, I guess we'll find out afterwards. So I do kind of want to start in somewhat the same spot that we did last time. So you have litigated over 700, we said 70 last time by mistake on typo, 700 defense suits for all different types of companies. And we talked a lot about in the financial sector, banking, kind of insurance as well, that you're working in now. Recently worked with Allstate to kind of help them make sure they were compliant.
Well, we spoke with Allstate. So Allstate is not a client. Okay. And if Allstate's watching,
you're good.
Anytime, guys. But we did speak at their mega agency conference last year to help the agents there to understand the law. And I'll tell you, there was a lot of misinformation, and a lot of folks were very obviously grateful to receive the information that hopefully we'll be able to provide today as well.
Awesome. Great. Well, so like I said, I really went back through and made a list of questions. We asked our customers, some of the viewers, my inboxes and messages were inundated with questions after the webinar. So we are going to kind of take a question and answer type of approach here. But like I said, we are going to start in the same place. Can you give us a general overview? And maybe in this overview, kind of focusing on really the difference between that ATDS, when that applies and when it doesn't. Because we had a lot of questions, a lot of people were confused as to manual versus that ATDS system.
Well, it's very confusing. So let's just talk about the TCPA real quick. Those of you that follow my channel, you guys know all about this, but let's just break it down. TCPA has two primary components. Component number one is what we call the regulated technology component, and we'll talk about exactly what that means here in a second. And the second component is the DNC provisions, the National Do Not Call Registry provisions. Two totally different restrictions that live within the same statute. You have to comply with both of these restrictions, otherwise you could be sued. The penalties for violating either one is $500 per call, up to $1,500 per call. Class actions are enabled. There's a 4-year statutory look back, so it's not just, I called a guy one time. No, everyone that you've called for the last 4 years can be brought into a single lawsuit called a class action. All right, so you've got two regulations, two restrictions you have to think about. One, regulated technology, and in order to use regulated technology to contact a cell phone, you have to have express written consent, which is a very specially defined term. We'll talk about that here in a second. But what is regulated technology, right? That's going to be the question, and we're going to answer that. The second provision, though, is simply thou shalt not make marketing calls to phone numbers on the National Do Not Call list unless you have prior express invitation or permission, which also has to be in writing, but is different statutorily than prior express written consent. We'll talk about that. Or if you have an established business relationship, then you can call numbers on the DNC manually. You can't use regulated technology, because if you do, you're in the regulated technology provision, okay? So we're going to set aside DNC for a second. Let's unpackage a little bit of regulated technology. Regulated technology, these are technology platforms, outreach channels that are heavily regulated by federal law. One that's the most confusing is the automatic telephone dialing system, the ATDS. commonly referred to as an autodialer, but that's not the way Congress has written the statute. Okay, so the word autodialer does not appear in federal law. What you're looking for is the phrase automatic telephone dialing system. That is one piece of regulated technology. Others include any form of AI voice, any form of pre-recorded or artificial voice, any voicemail, IVR, or ringless voicemail. All of that is regulated technology. So what is an automatic telephone dialing system? There is a reason that people are confused, because this is very confusing. As defined by the U.S. Supreme Court in a case called Facebook versus Duguid, that's actually spelled D-U-G-U-I-D, but pronounced Duguid, as if there's a C and a K in it. There's not. In that case, the U.S. Supreme Court held that an ATDS is any system with the capacity to use a random or sequential number generator to either store or produce telephone numbers to be dialed. And I know everyone that's listening to me says, oh, well, that's easy. I don't randomly create telephone numbers. Yes, but that's only part, right? There's that second piece of storage. How do you use a random or sequential number generator, which I'll just refer to as an ROSNG from now on? How do you use an ROSNG to store telephone numbers to be dialed? That is the open question that plagues courts across the country. The U.S. Supreme Court has suggested in something called footnote 7 of the Facebook ruling that if you are using an ROSNG, or your system has the capacity to use an ROSNG, to determine the sequence in which telephone numbers are being dialed, that is all that is required to make your system an ATDS. And many out-of-the-box solutions, in fact, do have that capacity, because it's there for tie-breaking purposes. If your prioritization criteria, they got two data elements that are exactly the same, the system will generate a 1 or a 2. And whenever one's bigger, that's going to get called. And if it's a 1, it gets called second, right? And so technically, you've just used a number generator to determine the sequence in which your numbers are being dialed. That would make your system an autodialer, even though you're not intentionally using that capacity, because you want your system to dial in the order that you've pre-selected. Nonetheless, the fact that the system has the ability to do that makes it an autodialer. The other place where we see this all the time is with load balancing. There's limited throughput, particularly around text messaging, but sometimes with voice calls as well. And when an outreach is attempted, many times you have to segment that out. You can't have every single call going off at noon. Mm-hmm. You want some at noon 01, you want some at 11:59, and they'll use randomization to segment which calls are going to go at which time, or node assignment, right? When you've got limited throughput for your own systems and servers, and you have to have the work balanced by different nodes. Many times the segmentation will take place randomly as well, and all of that can result in phone calls being made in a manner that are actually now prohibited and regulated by federal law, whereas if those little elements of code were just removed, it doesn't matter that the system is being used in the exact same way. Just because the code is in the system, it is now an ATDS, whereas if the code wasn't in the system, it wouldn't be, and it's mind-boggling, but that is the law.
So really, it kind of sounds like that any system that is going to send out pre-scheduled messages at all is going to fall under that ATDS most of the time.
Potentially, that is correct. So
as a small business owner, though, trying to navigate this, and like we talked about on the last webinar, I said, what questions could we ask our phone provider or our CRM or the systems we're using to send out messages to find out those questions? And even if they say we are not an ATDS, and we have that written as a small business owner, but it is, and we were given incorrect information, we could still then have unknowingly violated the TCPA. Of course, there would be potential litigation against them for giving us false information.
Yeah,
we could do that. But to kind of err on that side of caution, it almost sounds like, if you're not sure, treat it as it is and make sure you have all the right compliance in place.
Yeah, the really tough thing about the TCPA is it doesn't care what you were trying to do, right? It doesn't care that somebody told you, hey, this is okay. It's strict liability is what the phrase is. So, in criminal law, and many times in even in civil law with lawsuits, you're not in trouble unless you intended to violate the law, right?
Yeah.
But that's not true with the TCPA. Either you did use an ATDS or you didn't. And if you did, it doesn't matter that you didn't know you were using one. It doesn't matter that you didn't intend to use one. It doesn't even matter that someone told you, hey, I promise, stack of Bibles, this isn't an ATDS. Doesn't matter. Either it is or it isn't objectively. And if it is, you're going to be liable. So as a small business, you're right. It's best to assume that unless you're using a purpose-built solution, right? There are some like Safe Select is out there. Drips has something called Initiate, and now a platform called Convoso has a product. I think it's called Call Catalyst. All of these, have been reviewed by me, and I've confirmed that they're not, at least at the time I reviewed it, an ATDS. But unless you're using like a purpose-built solution, you should assume that any scale auto dialing, automated, even if it's a power dial, or even if it's progressive, whatever they want to call it,
or for
right?
text as well, right? Call and text.
For call and for text messages, that's right. You should assume that any of these bulk systems are going to be potentially an ATDS. And again, there's a massive uptick right now going on with TCPA litigation. We're expecting, and we're already seeing it. I mean, the cases are just pouring in, and we haven't even got to the new rule, right? So, if I'm a small business owner, I mean, you got to balance. On the one hand, you want to grow, you want to have strategies for growth, but on the other hand, you just have to be smart and not get yourself killed, because these lawsuits will end your business in many instances. And the sharks that are bringing these cases, they're just, I mean, I'll be honest, some of them are just terrible people, and they don't care that it's a small business and, it's a mom and a pop, and they've put 10 years into building it, or sometimes 20 years into building something. They'll go after you, and they'll take every penny you've got. And
well,
I've seen
and it doesn't
happen.
stop at the business, right? That was something else I didn't know.
That's
the
right.
TCPA also, it can follow you personally.
That is correct. Yeah. So unlike, again, other areas of law, so what makes the TCPA so dangerous? In most areas of law, if you work for Chevron and you're the guy that dumps all the oil into the Gulf of Mexico, right, assuming that's illegal, you're not going to be sued personally for doing that, right? Chevron might get sued, but you don't get sued. But under the TCPA, that's not the way it works. If you are the caller, if you are the campaign manager, if you're the one that sets up the campaign or the strategy around leveraging leads, for instance, to make outbound calls, if you're in that process in any way, then you can be potentially personally liable for any violations that take place. And again, it doesn't matter if you thought it was legal, right? It just doesn't matter. So it's a gruesome statute. It's terrible. And yes, there are many stories of people who are small companies, and they'll say to a guy like Anthony Peronic, he's the wolf, the plaintiff's lawyer, one of the most feared plaintiff's lawyers, and they'll say, hey, look, I'm a small business, so what? I'll just shut down my business. What are you going to do? And he said, oh, that's fine. I will now sue you personally, and I will take your house, and I will see you in bankruptcy. And he has done it.
So he's the wolf and you're the lion.
I am not the lion, although that is my spirit animal.
That's you.
And I do have the lion right
logo.
here. But I am, of course, the czar.
Right.
But yeah, he's the wolf, and he's earned his reputation for a reason. But yeah, no. So bottom line is, you can't run from the TCPA. It is something that you have to do right. If you don't do it right, then you are in harm's way. No question about it.
Yeah, that was a big discussion in some of our circles about the size of the business and whether they should really worry about this, or is it even worth someone coming after them? And before our webinar, I didn't know that someone else could sue you. I thought it was just the FCC you really had to worry about coming after you. But anybody can really bring that lawsuit.
That's right. I mean, I think people focus, maybe appropriately, on regulators, the FCC and the FTC. And sure, they're active, but that's not your risk. Your risk is the private right of action. Any human being that you call, if you violate the law, they can sue you. And there are highly talented attorneys who specialize on the plaintiff side in bringing just these lawsuits. And yes, they will definitely look for the big companies. They want the big companies. But while those big company lawsuits are lumbering along because they take years, well, guess who they're suing to pad their pockets in the meantime? They're suing a bunch of the smaller companies, people who they can't really afford to litigate for very long. And I mean, look, sometimes it looks like extortion, right? They'll basically say, hey, look, either pay me $20,000 or I'm going to sue you in a class action,
wow.
Right? And it's just, it's a gun to your head. What do you do? Because they will file, right? And so now you've got something public, you've got a class action out there, everyone knows, and if you lose, oh my goodness, it's going to cost you hundreds of thousands or millions or even tens of millions of dollars, depending on your scale. Or you just pay the $20K, the blood money, and you walk away, right? And this is tough.
And these attorneys are also advertising this. Like, we're seeing even just like standardized Facebook ads, right? Just something simple that's literally asking the general public if this has happened to them and that they could be entitled to compensation, right? So like trying to drum up these lawsuits as well.
Yeah, the highest paid lawyers in the country right now are not the lawyers in big law firms. They're not the snooty guys that went to Yale and Harvard and are at the biggest law firms in the country. They're the guys bringing TCPA lawsuits. They've got higher salaries. They get bigger bonuses. They are incredibly well paid and incredibly well compensated, and they are really dug in. So again, please don't think, oh, hey, it's not going to happen to me because the FCC, the FTC, what are the odds? Look, you might live a charmed life. I've got clients that never get sued, and it's really interesting to me. Obviously they try to do it right, but they make millions of phone calls and never get sued, and that's great. And I've got other clients, I'm telling you, these guys make 1,000 calls a month and somehow they end up in a class action, right? It makes no sense. But I guess the point is, just because you feel like you're a small business or you have a small footprint, don't allow that to give you a false sense of security. Sure, you might not end up in a lawsuit. Of course that's true. But you definitely might. And if you're not doing it right, it's going to be very costly.
Well, and doing it right isn't necessarily costly on the front end, right? So if you just take the time to understand what needs to be done, put in the right protections in place, document it well, then you can operate your business without staying up and worrying about these lawsuits because you have taken the right steps. And the implementation isn't really that really expensive for a small business owner. It's the right opt-in forms, the right disclosure, which you have already given out at the Troutman and Mean 15, which gives you the guide that you need to use for your opt-in forms, and then take the time to make sure you and your staff understand how you can interact with customers, keeping your lists updated, and then you don't have a lot to worry about.
No, I love it that you said that, right? So I think there are two mindsets that are equally dangerous and poisonous that people need to get out of. One is saying, oh, the TCPA doesn't apply to me, I'm not worried about it. That's a terrible, terrible mindset. But the other mindset that's almost equally as destructive is saying, oh, well, I just can't figure this out. I can't apply. So I'm just not going to use leads and I'm going to not do outbound calling. Neither one of those is a productive or healthy business mindset. You cannot ignore the TCPA, but nor should you be so afraid of it that you don't even try, right? Yeah, the rules are pretty tricky. That's true. But if you spend a little time and educate yourself, and especially if you can get yourself an attorney, but if you can't afford an attorney, there are thousands of articles. Literally, we're going to be over 3,000 articles on tcpaworld.com this week. So much free information, and we don't put any barriers around that. You don't even have to subscribe. You just go visit the website, use the search function, find whatever you want. It's all there and available to you, and you're right. For the new one-to-one rule, which we haven't really talked about yet, for the new one-to-one rule, we at Troutman and Mean have tried to make this as easy on the entire world as we possibly can, and we've gone off and prepared a template disclosure for lead sellers to utilize and for lead buyers to be using as their checklist to make sure when they're buying leads after January 27, 2025, probably, we'll get to that.
I saw the article. I subscribed, so I got the email that said a potential stay. We'll get to it. But anyways.
So the Troutman and Mean 15 is out there. It's got all the things that you need to be able to assure yourself that you're complying with the new rules whenever they become effective. And so, again, the point is, you can do it. You can. It can be done. And that's actually one of the big takeaways that we always deliver when we stand up on stages and talk to people is, please don't get into this mindset of, oh God, I can't do it. You can. You can comply with these rules. It's a lot easier with a guide, like legal counsel, certainly. But even without legal counsel, if you really spend the time, these things can be navigated. And the FCC, by the way, and the FTC both have small business guides as well that you can also look to. So there's a lot of information out there.
And there's also a lot of bad information out there, right? So
that is true.
I have to say that I was part of that a little bit because I was getting my information from some of the phone providers that I work with, some of my partners there, companies that, people ask us, they're doing automation and like, which should we use? What's the best, what's easier, what has good tech? And so we'd recommend things. And when all of these conversations around text opt-in and some of the things started changing a couple of years ago, I was listening to these different individuals at these companies who I now know were also very misinformed. And so it is, that's why when we tried to do our webinar on Thursday, we did our webinar, it didn't record. I mean, it's what's today? Today's Wednesday. It was less than a week, hopped on a plane and flew down here because I know how important this is to be right for agents and small business owners. And if you aren't getting the correct information, like how much risk you can be at. So we talked about, that your phone provider says, and we're not an ATDS and there's potential, litigation there. But is there responsibility on these people who are giving out incorrect information?
I wish, so look, first of all, to protect yourself and make sure you're getting information that you can rely on. again, either be looking at authoritative government websites like the FCC or the FTC's actual websites, or, as we like to say, look for the lion, okay? If you see our lion logo, the Troutman Amin lion logo on the website that you're looking at, then you can trust that that information is coming from me, right, or from my team, and it's something you can rely on. Now, look, it's not legal advice. I'm not telling you that I'm your lawyer and everyone that reads my articles can sue me as their attorney. No, but it is reliable information that I, as a legal professional who have spent literally 15 years of my life doing just this, am willing to put out publicly, and I want people to be able to have a place to go where they can trust the information that they're receiving. People who are misinformed and sharing bad information, look, it is just a fact. In TCPA world, for the last 15 years, I've been trying to deal with people who are wrong. And there are people who are innocently wrong. They just don't know any better. And then there are people who are exploiting misinformation because their platform, they want it to be able to sell it, right? Mm-hmm. And so they'll tell you, oh, the TCPA doesn't apply to us, or you don't really have to worry about the TCPA, or you got these, what do you call these guys, influencers sometimes on social media saying, oh, the TCPA, oh, it's just a couple of complainers, who cares? I settled it for $500, it's no big deal. Like, these guys are just straight lying to you. And they're doing it for whatever their agenda is. I couldn't even tell you why half of the people do the things that they do. But bottom line is TCPAworld.com, FCC, FTC. There's a few other resources. We publish an annual review that's totally free. You can get your hands on it. Where I break down personally over 800 cases and kind of like lay them all out and put them into a usable format so you can understand the law for yourself. Of course, we have the YouTube channel where maybe you'll be watching this video right now. You should subscribe to the YouTube channel. Lots of free information. So again, we try to give authoritative information. I am sorry that there's so much misinformation. I am sorry that you may have heard something different than what you've heard here today. They're wrong. I'm right. And I have no problem saying that. And many times I get on stage and I'll just call people out. Hey, you person in the audience, I heard you said X. Don't know if that's true or not, but if it is, you shouldn't have because it's wrong. So very happy to take on the laboring oar of trying to educate folks because, people need information. Mm-hmm. They really do.
It's a heavy lift for sure. Yeah, and I did after we met, I even just did a quick search on YouTube, just put in your name, and there are dozens, if not more, of these recorded sessions that you have done. And I will say too, after you listen to a couple, 2, 3 of them, it does start to sink in. It starts to make sense, starts to connect. Because if this is the first time you're hearing it, it can be a lot to take in.
And it's crazy how consistent they are, right?
They are very consistent.
Isn't that amazing?
It's the same messages. I started writing down questions as I was listening, and then a little further in the webinar, you would answer the question, or it would be answered another one because some of the topics would change. But obviously, just all consistent. There was nothing that was conflicting. With that being said, I do want to jump into some of these questions.
Yeah.
So we've already established that even if you aren't doing anything automated, you're not doing voicemail drops, you're not doing auto dialing, you aren't doing automated text messages, and you say, hey, I'm just going to do manual, which we said, of course, that's not going to help you scale your business, so that's not a great answer to that. But even if your phone system has that capacity, you could still be subject to TCPA.
Yeah.
So it is a best practice, because that was a big conversation after the first webinar. I'm just not going to turn off all my automated, but that still isn't necessarily going to protect you.
Yeah, no, it's pretty wild the way that works, but that is correct. If your system has the capacity, it doesn't matter outside of the Third Circuit Court of Appeals. There is, if you're working exclusively within the states of Pennsylvania, New Jersey, and Delaware, the Third Circuit Court of Appeal there has held that the use of randomization is required as opposed to the system's capacity, but anywhere else, system's capacity is what's looked at. So it's just a little wrinkle.
47 states. It does. You just be careful.
It's a little wrinkle. Right.
Okay. So we're just gonna for the rest of this, we're just gonna say that you're using an ATDS system.
Okay,
because we know that the manual and the fact that ATDS is not what you're using is probably a lower use case, especially as phone systems become more than phone systems, right? Mm-hmm. They have AI capabilities and they have all these other pieces and the ability to add dialers and things like that. So customers. So there's going to be some repeat from the webinar, but existing customers, can we call and text them without opt-in?
You cannot. So every lead that you have, every single record
just customers,
in your
existing
CRM, customer or not, doesn't matter. You cannot call them unless you have valid one-to-one express written consent after January 27th or whatever it becomes effective. using, because we're assuming now regulated technology.
Right, we're going to say regulated technology for the rest of this.
Yeah, we're using regulated technology. The answer is every one of your leads, every single customer record you have, your own customers, you cannot call them.
Okay.
Ta-da. Terrible. Isn't that terrible?
Terrible.
Isn't that terrible?
Let's all pray for that stay to happen, so at least we have a couple more months to get opt-ins.
Should we talk about the stay real quick?
Sure, yeah.
So January 27th it currently is, and perhaps we'll soon be saying was, the date of the effectiveness of the new one-to-one rule. However, when President Trump was inaugurated on January 20th, which is 2 days ago for us, he signed an executive order that required all executive agencies to stay implementation of rules that had not yet been published in the Federal Registrar, and to consider staying any rule that had been published in the Federal Registrar but had not yet become effective as of the date of the order. So we, as the president of REACH, we have filed an emergency petition with the FCC citing President Trump's order and asking the Commission to consider, which is the language that's in the order, to consider staying this rule for 60 days. Now, a couple of issues here. One, the rule says that the Commission has to consider it. It doesn't say that the FCC has to actually stay it. Now, I think that the intent ought to be that the order be stayed, but ultimately the Commission has to make that decision. Secondly, and really kind of more of an interesting legal issue, is the order only applies to executive agencies, and the FCC has never been determined to be an executive agency. And it's unlikely that they're going to want to call themselves, and for the first time ever, an executive agency in response to our petition or response to President Trump's order. Nonetheless, the Commission has the inherent authority to stay the ruling regardless. So REACH is hoping to use the hook of the executive order to bring on a stay, either because the Commission decides, you know what, we are an executive agency and we're going to honor the stay request accordingly, or even though we're not an executive agency, we're going to exercise our authority to do so. Either way, we're hoping for a ruling, and frankly, by the time this video airs, that determination will probably already have been made. So check out tcpaworld.com to find out which way it went.
Know what happens.
Yeah, that's right.
Yeah. Okay. All right. So I'll opt in. So collecting the opt-in. This has been a huge conversation. People would say, well, we're just going to send an email, and if they reply to the email and say yes, then we have an opt-in. Or they are going to, if they text us, they say yes, we want to opt in, and then they're taking that as a documented opt-in. Or if they're on the phone and are getting verbal, if they are saying to them out loud that they are opting in, and they say yes, and they have the call recorded. So what is a valid document? What does it actually look like, a valid documented opt-in?
Yeah, so 2 out of 3 of those processes is actually feasible. Let me just start with the call recording and just address that directly. You cannot get express written consent
verbally
over a phone call. Okay, it can't be done. It literally cannot be done. Now, you can use a different process where you're encouraging the consumer to go onto a website, or you're sending them a text message under certain circumstances, and it contains all the required information, and in fact the consumer does respond with an appropriate signature in response to a text message. Great. But if you're just trying to get them on the phone and record them saying yes, no. The answer is no. A phone call is not a writing. A recording for purposes of e-Sign Act is not a writing. You have to have a written agreement. Now, people get confused because the e-Sign Act, which is the federal law that determines whether or not a signature can be obtained, allows for an oral signature. So if there's a written agreement right in the consumer's hands, and you have a process, for instance, where you ask, do you accept the terms of the agreement, and maybe like a little serial number that matches what's in the consumer's hands, and they say yes, that actually would be a valid express written consent. But the idea of just like reading them the disclosure and then having them say yes, even though it's functionally the same thing, completely illegal. It's not a written agreement. So you can't do that. Now, can you do other things? Obviously, if you drive them to a website and have them fill out a proper form that has the Troutman Amin 15, yes, that is going to be a valid express written consent. People want to use email. Yes, email can be used, but it can't just be a yes response to an email. you'd have to embed all the requirements of the Troutman Amine 15, and there'd have to be a formal signature apparatus of some kind, either a click-through or some other means that you're using to actually capture the consumer's assent and signature to the full disclosure terms. And the same thing is true for text messages, right? Both emails and texts can constitute a written agreement if all the terms are properly laid out. Text messaging is actually very challenging, but we've helped consumers and clients, not consumers, excuse me, companies and clients to do that. So it can be done, but it's tricky. But obviously the easiest way to do this is to get people to go to your website and fill out a form. And that's true obviously for new potential customers and for your existing customers.
And then, so on the storing of emails and text messages, if that's the route that you are going to use,
Yep.
it is more difficult. I agree, the form is just the easiest way to go. But then you have to store that information.
Yes.
So if you don't have a way that you are grabbing the email or the text message and actually storing it, you said for 5 years,
Yes.
right? Then whether that existed at some point or not, if you can't produce it, it's like it never existed.
That's right, and I would say for at least 5 years. So remember, you've got a 4-year statutory look back here, right? So if you've got somebody that came into your, your company in 2020, and they signed up and they've been your customer and they're your customer for, 10 years, and now we get into the future and now it's 2030, right? And you're still trying to contact this person, you should probably have that record of consent, even from 10 years before. So if they're a current client, you should not ever be deleting whatever records of consent that you have. If they're a customer that's moved on, you don't want to treat them as a lead, you don't plan to contact them again or use an existing record of consent to ever contact them again, then at that point you can feel safe. And typically we say wait for at least 5 years because many times people do want to contact those aged leads, right? They were a contact before. Hey, that express written consent, it doesn't expire. They never said stop calling, so you still have a valid express written consent. So you might want to make use of that. But so long
But
as
that's only for customers. Customers' express written consent doesn't expire.
Nobody's express written consent expires,
Oh,
even non-customers.
So leads, prospects
Yeah.
that opt in,
Yeah.
there's not an expiration date on that?
If it's a valid one-to-one
Okay.
lead, so the way it works is a consumer can revoke their consent at any time, but an express written consent document never on its face expires. It's just not like an expiration date on it, unless, of course, the FCC changes the rules, which they just did, right?
Okay.
So everyone's express written consent that they've had for the last 10 years just expires essentially
Because it wasn't
on
one-to-one.
January 27th because it wasn't one-to-one. So again, the commission, who knows, 5 years from now might change the rule again, in which case all these express consents you're getting today aren't going to be valid when that new change takes place, if it does. But until that happens, that express written consent is valid unless the consumer says, stop calling me, or unless they engage in other behavior that the caller knows they want you to stop calling, right? And there's a whole nother set of rules called the revocation rules, which the FCC is going to be, they've already announced, and they're going to come out April 11th. And these are very expansive, and they're real list killers, I got to tell you. So just be aware that those changes are coming as well, but it's a little bit different than the one-to-one rules.
Okay, so we have to get an opt-in for all of our customers to be able to call and text them. We have to get an opt-in for all of our prospects, and we can reach out to those prospects and those customers as long as there is not an opt-out or they don't say something like, take me off the list, stop calling me, go pound sand, all that good stuff.
Yep.
So we're good there. And then what about that? How does that extend beyond the agency? So for an insurance agency, they have team members in the agency who are calling, staff members. They also might have 1099 subcontractors who do outbound dialing for them, or 1099 producers. They also could have maybe hired a virtual assistant company, which is becoming more and more popular
Sure.
as wages become more expensive in the States. So this is actually a third-party company calling where the VA is employed, but the agency has hired that company. So how does that extend? Does that need to be disclosed?
So interestingly enough, under the new one-to-one rule, the seller has to be on the form. The seller is the company that's providing the ultimate good or service to the consumer.
Okay.
This is actually very tricky in the insurance context, because if the insurer is the one providing the good or service,
The carrier.
right? Insurance, right, the carrier, then the carrier's name has to be on the form, and theoretically nobody else's name does. But when the agency calls, or the VA or whoever it is, 1099, whoever it is, they are technically calling on behalf of the carrier. So they have to have the authority to be able to call on behalf of the carrier. Otherwise, they're not going to be able to buy that lead and leverage that lead. And if you're a broker, you're not captive, and you want to be able to sell multiple products, understand if that lead form says Progressive, you can only sell Progressive. You can't sell anything else. So for many people, you as a agent, you can't buy a lead that has only a specific insurance form or insurance brand on the form. So what do? Well, you have to recognize that you are actually not selling insurance, you're actually selling assistance finding insurance, right? So basically everyone becomes a broker. Whether they intended to be a broker or not, or they're licensed to be a broker, essentially from a one-to-one FCC perspective, everyone that's selling insurance is now a broker to the extent that you're not going to sell only one specific product. If you're captive and you're only selling Progressive and that's all you're ever going to sell, then just buy the leads that say Progressive and you're fine.
But even then, they can have, like, for example, Farmers Insurance agents. We have a lot of those agents, and they have different, Farmers Insurance Trucking Exchange, and they have
Right.
they have different sub-carriers that still sell auto insurance with Farmers, but they're
Right.
different carrier name or subcompanies.
And this is a massive issue. It's a massive problem because as written, the rule has no flexibility for that. You have to have the right entity writing the right policy for that consumer at the time they fill out the form. And I understand in many instances that's just flat not possible. Now, this is an issue that REACH, again, Responsible Enterprises Against Consumer Harassment, you should all join REACH, reachmbc.com, go check it out. REACH has talked to the FCC about this. There are comments pending, and we believe that at some point, I mean, it's a little bit slow, the administration has changed over, right? So, pencils had to go down for a couple of months. But it is our belief that the Commission is going to hear the concerns of folks like Farmers or Allstate that, hey guys, really, the consumer is agreeing to hear from a brand.
Right.
They just want to hear from Allstate. They don't care if it's Allstate Truck and Casualty or it's Allstate Casualty or it's Allstate Delaware. They don't care. They just want to hear from Allstate, or they want to hear from Farmers, or they want to hear from Progressive, right? Whoever it is that they signed up with, that's the brand that they have selected, rightly or wrongly, that they want to hear from. What does it matter if that specific entity is divided up either geographically or based on risk or whatever it is, right? The FCC has heard us. I believe the FCC understands that concern, but no action has been taken on that yet. So all I can tell you is come January 27, or if it stayed, whatever date of effectiveness, unless the rule is modified, there has to be a perfect entity match between the product the consumer is going to have and the name on the form. So what many folks are considering doing, particularly brokers, of course, is you're not going to buy a lead that has Progressive on it. You're going to buy a lead that has your brokerage on it, but the website call to action can't be, hey, come get a great insurance quote. It has to be, come find the right insurance for you, or get help finding the right insurance for you to make the good or service that the consumer is signing up for, not insurance. Because if it was, then the carrier's name would have to be on there with all the problems.
So it's the
but
assistance
the broker
in finding the insurance
is now the good or service that's being provided to the consumer.
So really a change in the way that you're even marketing your agency.
Absolutely.
Because if you're going to have your opt-in form, say like when I had my agency, it was Base Insurance Agency,
Mm-hmm.
LLC. So if I wanted my form to say that, on my website I couldn't say provide insurance.
Correct.
I would have to say that I assist community members in finding
The right insurance for them.
dang these verbiages.
Isn't that crazy?
Specific pieces.
And again, I can guarantee you that is not what the FCC intended.
Sure.
And that's not what they were trying to do. But that is the outcome of the wording that was utilized in this rule. And again, we just trying to get them to recognize this, make a couple little common sense changes, just change the word
Entity to brand, just make it, this is easy stuff. But it hasn't happened yet. And so until it does, we're stuck in this really weird world.
Jeez. Okay. So specific. So that actually goes back to, so we kind of know who can reach out, and it is technically the carrier. So I guess I'm going to circle back on that VA question again, because through the authorization of the broker, which is the agent, we're going to call them brokers from now on, we have said, hey, VA company, like you can call, and reach out, but they don't have any authorization from the carrier. Who's providing the service? So our opt-in again has to be with our agency name, our business name, so that it could wrap in that VA company who we have hired.
Well, it just depends if the carrier has given authority to the agent broker and all sub-affiliates, right? So
If it covers
yeah, and that's what flows through. So from a TCPA perspective, the TCPA doesn't care who's calling. The TCPA cares that you're being called on behalf of Progressive, or you're being called on behalf of Allstate. That's what the TCPA cares about. Now, Progressive might care, right? If you're providing information for a potential Progressive consumer all the way down to a VA, right? That might be an issue for the agency dealing with its contractual obligations to the carrier it's selling policies for. I leave that to y'all to figure out. But from a TCPA perspective, the consent is going to be sufficient that so long as anyone in that chain is calling on behalf of the good or service provider, they're going to get covered automatically by the form. At least that's, one lawyer's view. Obviously, get yourself another lawyer if you want, real legal advice, but that's my opinion.
Okay. So I want to talk more about the lead coming in. So there is a requirement now with one-to-one that not only does the one-to-one have to be captured, but it has to be documented. If you're buying a lead, you have to have a copy of the one-to-one in your business. Is that correct?
Yeah, that is correct.
Okay.
So, in the old days, like today, it's best practice to have that in your records, because if you get sued, remember 4 years, you get sued, your lead partner has sold you a lead. Oh, I promise it's a great lead. It's real. Oh yeah. Well, 4 years ago, they better come and produce it to you when you get sued, right? So you probably already want to be taking possession of these lead records. But come January 27th or whenever the rule is effective, now you are actually required to, as a matter of law, have possession of the full consent record before you make an outbound call, which is a really interesting question, because how do you take possession of an online web form submission? It's an open question. No one really knows yet, because this hasn't been tested in the law yet. Obviously, there's things called trusted form and Unaya. These are third-party witness attestation programs. They have tokens that you can download, a visualization of what took place. And these are things that people should really consider taking possession of. But I don't think that you necessarily have to do that, but you do have to have some sort of visualization of the record on the day the consumer submitted the form.
Wow. What about live transfers?
What about it?
So if you are buying live transfer leads, that was part of the discussion that happened after our webinar was, well, I'm just going to get rid of all of this and I'm just going to let the lead companies call and then live transfer them in.
Oh, no, that's a much worse situation for you. So live transfers are the most dangerous thing, because now you're entirely beholden on somebody else to have got it right, and you're on the hook if they got it wrong, right? So if you're buying data, at least you, in theory, know who you're calling, you know who your data vendors are, you know what systems you're using, you know your cadences, right? You have a lot more control. If you're buying warm transfers, understand you're still on the hook, right? That call was made on your behalf. Or Progressive's on the hook if you're selling Progressive, but guess what? They know it's coming through you, right? So now you're on the hook to the carrier. So you're either going to be sued by the plaintiff or you're going to be sued by the carrier. It's not where you want to be. Now, if you've got a great warm transfer partner, and they're like, let's say they're a reach member, let's say there's somebody who's really, really good, and they got really good consents, and they're doing everything right, and you're just going to sit back on easy street and take those calls as they come in, great, right? I mean, honestly, that is a win for you. But it is, just understand, you are pregnant with everything they do. I mean, everything. So if they're fantastic and they take good care of you, well, that's wonderful. But I heavily advise my clients to not, either don't accept warm transfers.
Or if you're going to accept warm transfers, I mean, you need that deep level of vetting with these partners. Unfortunately, most of the small businesses, like you guys, are probably not going to have that ability to really force change with the lead sellers or those who are giving you warm transfers. So you want to be cautious. But again, if you want to join Reach, we do have some companies, some BPOs and others that are very good companies, get very good leads that are they have fraud detection. Very important to use fraud detection to make sure these are real interactions. And so there are good companies out there that do it the right way. You just have to be really careful.
Okay. And then I want to ask more about the opt-in form around the carrier specifically. So just recently, I just went online real quick and pulled up Farmers Insurance, and they had changed their opt-in form, and it has the ability to select carriers, right? Which of course we talked about was needed. Now I'm the agent. I get that contact and it says I can quote Farmers Insurance and it says the name of the company. But let's say I know that there's a better rate for the agent with Foremost Insurance, which is also under the Farmers umbrella. And I'm just picking on them because I just looked it up the other day. And so if I'm on a phone call with a client and I did quote them Farmers Insurance and I say, hey, there's probably a better rate with some of these other companies. Would you like me to provide you quotes with those companies as well? Is that allowed?
If the consumer has selected a box that included the proper farmer's entity and Foremost, then the answer is yes. If the consumer has not checked a box that included Foremost, then the answer is no.
So even out of a verbal conversation with the client,
Absolutely.
we've offered more services. So would the solution then be to say, hey, would you like this quote? And if they say, yes, I'd like a quote with Foremost, we get another opt-in that includes Foremost before we quote?
Yeah. So you'd have to remember, though, once you make the phone call, everything that's required to obtain consent has to have taken place before the phone call. So
right.
So what you'd want to do is get the consumer to check as many boxes as possible on the first form. If you want to keep the consumer going through multiple flows, you can. There's no rule that says you have to stop when they say Farmers, because you can say, hey, while you're here, you'll hear from Farmers. Do you want to hear from Foremost? Do you want to hear from somebody else? Like, you can keep online, trying to sell them additional things. But once you pick up that phone, your hands are tied. The only thing you can sell on that phone call is what is on the form.
We can't offer additional carrier services.
You cannot.
Wow.
You cannot. That, I'm telling you, that is the rub here, right? And that's why for brokers, basically you can't buy a lead that has a name on it anymore, because you're bound.
You're stuck with it.
You're bound to provide the right insurance product for that consumer, right? And if it says Progressive on it, and Geico's got a better rate, got better coverage, my goodness, what do? Right? You've got fiduciary obligation to tell them about Geico, but the TCPA says you're not allowed to tell them about Geico.
So this is probably a rabbit hole, but I do want to go down a little bit, because whether it's captive or independent, a benefit for an agent is the whole point of an agent versus just calling Progressive Direct or Farmers Direct is the fact that you can get multiple quotes from multiple carriers. Right. That's the benefit. And the agent knows the underwriting requirements and the rates and probably what's going to be best. They can get you a few options. So is there any way to go back after initial contact? They go to your website, they say, I want Farmers, they don't pick Foremost, and we've quoted that. Is there anything else we can do? Like, let's say they don't buy the policy, we send them an email that says, if you'd like quotes from more, here's another opt-in option. What can they do to still be able to tap into their other carriers? Yeah,
so email is always available, right? So let's talk about from front end and back end. Okay, on the front end, again, so I keep saying, developing new calls to action and working with lead generators who are kind of specializing, frankly, in the insurance vertical and can help build out a flow where the consumer knows they're going to get information or be contacted by someone that can help them to find the right insurance as opposed to an insurance carrier, right? Because that's your first hook. Because if you can broaden out what you're allowed to call about in the first instance, well, then that's going to help you a lot. If it's narrow and you're only allowed to call about insurance products by Progressive, well, now you're stuck, right? And there's just really, on the front end, there's nothing you can do. So let's assume you got that, you decided to buy that narrow lead, right? And it's, insurance, it's casualty insurance from Progressive in California, right? That's what they want to hear about. That's all you can talk to them about, right? So you pick up the phone and you want to give them this, and, for some reason, it just doesn't work out. So what can you do? Yes, you can send them an email. You can, if they're not on the DNC list, you can pick up your phone and manually call this person. Because, believe it or not, in America, in most states at least, not in Connecticut, by the way, you can't do that in Connecticut, you can still pick up the phone, and if somebody's not on the DNC list, you can still cold call them.
But if if your system is an ATDS system, then that would be different.
That's why I said pick up your phone. So you got to step outside of your automated process. I know you don't like to hear that.
No, it's fine.
Yeah, you have to step out of
that's
that.
okay. And then that's where there's some confusion, because a lot of insurance agents, they're really not doing a lot of auto dialing. Like there is big agencies who use dialers, but most of what they're doing is their producer is picking up the phone and dialing.
Pick up the phone. Pick up your cell phone and make the phone call.
But if their phone provider is an ATDS system,
well, that's what I'm saying.
Even though we're manually doing it, we're good there.
Well, if your phone provider is an ATDS, you can't do it. That's what I'm saying. You have to pick up your cell phone, right? Your cell phone today, at least, the law could change tomorrow. But today, if you pick up your cell phone, and again, you're not like using an automatic, spy burner platform app on your cell phone. Yeah. That's not what I'm talking about. You just pick up your regular phone and you dial the number on your phone. you can do that. That is still allowed as long as they're not on the DNC list. If they're on the DNC list, unfortunately, this is basically a dead lead for you at this point, right? You can email them as much as you want. Email is a totally different rule, okay? Email them as much as you want until they say stop. You have to unsubscribe, but that's allowed. But that's basically your only touch, right? Other than picking up the phone and calling them, or picking up the phone and texting them, right? Again, if they're not on the DNC list. If they're on the DNC list, then you can't do that. You cannot. So it's not good.
Okay, so we get the lead in, we have to go with the carrier. But again, if we advertise that we are helping them find insurance options and the opt-in is for our brokerage, then we're free to do whatever carriers we want.
You absolutely sure can. The only issue there is, it just depends on your model. If you're going to write the policy, you're home, you're fine, no worries. But if you're going to somehow transfer that consumer to the carrier for additional work, that's a different issue altogether. The carrier is going to have to get a different level of consent in order to contact them back. And that happens for some people. But assuming that you've got the ability to just write that policy, get it bind and be done, you're done. That's all you have to do.
So another question on the captive side, where these disclosures, like there's usually a captive website for the agent with the agent's name on it. And it's the captive companies that are disclosed on the form. The agency name, like if my agency name was Gates Insurance Agency, is not listed on that, but the carrier sends me that lead. It was submitted on my website, so it says Mariah Gates Farmers Insurance. Their opt-in form has all of the farmers insurance companies, but my Gates Insurance Agency name is not there, and they send that to me because I am authorized to sell their products. I can call that lead.
Well, the issue there, it's a trick question. The issue isn't that Gates Insurance is not on there. That's fine. The issue is that you said multiple farmer entities are on there, right? And so if
each of their companies, like their carriers and the company, the entities that go with each of the products.
And are they independently checked by the consumer? Or is it all just part of one? Because if it's all part of one, then that does not comply with the one-to-one. That is not a valid lead. These are the first party issues that happen, right?
Got it.
You go onto farmers.com and they're like, you agree to hear from, Farmers family of companies. No, you can't do that anymore. Sorry, farmers. You're not allowed to do that. Until the FCC modifies its language, which hopefully it will, under the current language, it is entity specific, not farmers and all of its brands and family of companies.
So each one.
If there's 20 farmers entities, then the consumer would have to check 20 boxes. And if they uncheck any of those boxes or don't agree and they only want to hear from 3, then whoever is buying that lead when it gets sent over to Gates, right? That's fine. But Gates, you can only sell the 3 that were selected out of the 20. And you have to be able to figure that out and solve that in real time. Have fun.
Yeah. Doesn't sound like fun. How does this apply to referrals, right? What if an agent says, screw leads, I don't want to do this anymore. I'm not going to mess with it. I'm just going to work with referral partners, lenders, lawyers, CPAs, people who just send me their clients and say, reach out, contact them.
Yeah, so that's real tricky, right? But this is true regardless of one-to-one, right? This is already a risk. If I send you, hey Gates, you're great. My buddy Bob wants insurance. Call Bob. You can't do that. If Bob's number is on the DNC, just because I told you to call Bob doesn't mean that now you have the right level of consent to call Bob. It's not how it works. Bob has to call you, or Bob has to do something to make an inquiry to you. So the way it should go is I should say, hey Bob, call Mariah, right? As opposed to say, hey Mariah, call Bob. If I tell Bob to call you, that's totally legitimate and totally legal. If I tell you to call Bob, I just invited a lawsuit for you. It's actually a really good way to mess with people.
Now, you could give your referral partner like a landing page on your website or a form and say, hey, lender, if you want me to call your customer, the customer has to submit this consent, not the lender submitting a referral form on behalf of the customer.
Correct. And this is something that you and I talked about during the webinar, which is, we've got, Troutman Amin does now a pretty good amount of marketing, and we get inquiries from people that, have different kinds of cases that we don't handle. And so I'm like, wow, it'd be really nice to be able to do a referral. But in order to do a referral, if these phone numbers are on the DNC list, right, I've got to say, hey, look, in order for me to be able to refer you, you need to go to this website and fill out this form and accept this, this term. Otherwise, they can't call you because you're on the DNC list, which, by the way, is the way it should work, right? If you put yourself on the DNC list, you should understand there are consequences to that. And one of the consequences is you can't get referrals.
Yeah. Okay. Well, I'll be honest, I have no idea where we're at in time, and I can probably sit here for another 2 or 3 hours. Is there anything that like maybe common questions or from that small business owner perspective that you would want viewers to know that we haven't covered already?
No, I mean, I think we talked through all the kind of key points. Again, to me, what's most important for the small businesses to understand is there's a lot of misinformation out there and a lot of people trying to trick you. I mean, it's just the truth, right? These lead vendors, some of them are great people, some of them are absolutely terrible people. And the same is true for platforms. Like, Mariah, you're fantastic, and we're sitting here talking because you want to educate people, and I love that, right? But there are 10 bad people for every one Mariah. So just understand that, and understand that you rightly or wrongly, like, you have the responsibility to take care of yourself out there. And if you are listening to what a vendor is telling you without checking it, kicking the tires, and maybe getting legal counsel, just understand, right, you are in a heavily regulated industry, not just on the insurance side, but on the outreach side. Telemarketing, which is what you're doing, even if there's a lead, it's still considered telemarketing. Telemarketing is a heavily regulated activity in the United States of America, and you have to either have yourself an attorney to help advise you, or you have to take on that responsibility yourself. But either way, you've got to comply with that set of regulations. I mean, it's kind of as simple as that. Again, the good news is it can be done. There are a lot of resources out there, but just be careful who you trust, right? Look for that lion, make sure you're getting that information that you can rely on, and be very careful with what vendors are selling you. I mean, they're selling you. They're trying to sell you something, right? And unfortunately, it's not always truth in advertising these days.
Yeah, it's very true. The last thing I want to end on is, so we've talked a lot about the lead coming in and then how long we can talk to them and all those good things. What about the opt-out? So some clarity here, I guess. If we are calling them and they say, take me off the list, opt out, and that's an opt-out. In my understanding, if they reply to a text and say stop, that is also an opt-out. And text and call are treated the same when it comes to opt-out. Is that correct?
So this is a rule that's about to change.
Okay.
All right. Today, the touchstone is just common sense and consumer expectation. So if the consumer has signed up to receive, I'll pick on Wells Fargo, they signed up to receive notifications about ATM withdrawals. They've also signed up to receive information about, fraud alerts on their account. And separately, they provided a marketing, disclosure. So they've got a whole bunch of different consents out there that have been provided at different times, and the opt-ins on the website have been selected individually. And now, today, the ATM alert comes in, the guy says stop. Well, everything else is fine, right? You just have to stop that ATM alert, and in the future, don't send any more ATM alerts. In fact, one case involving Walmart and a prescription pickup said that the stop only applied to that specific prescription pickup. So the next time the consumer went in to go pick up a prescription, it was basically a whole new event, and the previous stop did not prevent Walmart from sending that message. So that's really interesting. But that's today, right? Come April 11th, we're going to have a completely new paradigm where the way that the FCC has structured it, anytime a consumer responds stop to any marketing message at all, it's going to stop and require all marketing to that consumer to end across all channels. One. More problematically, any informational text where a consumer says stop, now you have to stop all informational and marketing messages to that consumer across all channels for all purposes, unless the consumer responds to a one-time message that you're allowed to send to clarify, hey, consumer, what did you mean by that stop? And if the consumer doesn't respond, and guess what? They ain't going to respond.
So we can clarify. We can say, did you mean to stop receiving all text messages from our company?
You do get one.
Just marketing or just... Okay.
Yeah, you have 5 minutes to send one message to the consumer.
That's it, 5 minutes.
5 minutes.
After 5 minutes. So this better be automated or you're going to miss it.
You are correct. You've got 5 minutes, and you have to be really careful with how you phrase it. But if the consumer responds to that one, call it a savior message, where they're like, oh no, I just wanted to, and you have to frame it just right? Respond 1 to mean that you want to stop all communications, 2 to mean you want to only stop this specific transaction, 3 to mean stop messages of this type, whatever. You can do a message like that, and if the consumer gives you a response, then you are allowed to then tailor their revocation according to that response. Otherwise, if there is no response, then you have to take the broadest possible interpretation. Which is going to just be a real list killer for people. And it's really going to change. For small businesses, it's less of an issue. For enterprise businesses, I mean, my goodness. you might have 18 permissions to contact a consumer, and one of those gets burned and now they're all gone. That is not the way people operate today, but it's going to be the way they operate come April 12th.
So as of today,
crazy.
if somebody replies to a text and says stop, you can still call them?
So it depends. Again, if it's a marketing text message and the only opt-in that you have is for marketing, best practice is you're going to stop all marketing and put them on your D&C list. Some people, though, will continue to make outbound calls for marketing purposes and just stop the text messages. It's a dangerous practice. I wouldn't necessarily advise that. But some companies are doing that. It's like a risk threshold issue. There's not really a case law on that specific issue. But my advice, to the extent, you're not my client, but if you were, I'd say, hey, look, this consumer says stop. They don't want to hear from you about marketing. Continuing to call them is just going to bring a lawsuit to your door. So you really should think about that.
Well, that's probably going to make the consumer mad anyways. I mean, what are you trying to solve at that point? I think that it's good to know that clarification, even under the new law in April, revocation law in April, still allows you a response.
Yes, it does.
And you could always respond via email, right? That isn't going to change.
Absolutely.
So if they say stop on the call text, something like that, you could still send a follow-up email that says, was this kind of what you meant, and get that clarification.
That is
there
correct.
going to be a limitation on the email response time like there is text?
No.
Yeah.
So luckily, the TCPA is completely separate and apart from any of the email
Totally.
rules.
Okay.
So nothing that happens with the TCPA applies to email unless you are sending emails to the phone numbers at Verizon.com or something where it ends up becoming a text message. Anything that you're sending that becomes a text message on a consumer's phone is going to be treated under the TCPA. Anything that's just a regular old email that you access through Outlook on your phone or something, that's fine.
Yeah. Wow. Well, we've covered a lot, and then it's even changing more. You guys have to definitely go to tcpaworld.com and do just subscribe, because I've been subscribed for a week, and you guys aren't marketing to us. That's not what they're doing. They're literally just sending you articles and information to allow you to stay updated. That's the only reason I knew that there was anything to do with the stay until March, because I got the email in my inbox, and they are easy to understand. It's not like getting a normal email from an attorney or reading a legal document, because we've all done that in insurance, and it's extremely confusing. So they are very straightforward, easy to read, quick reads as well. I love the bulletin on the top, so you can see what it's about. And that will help you stay updated. So while we have a million things on our plate as a business owner, and this feels like just another thing, just take some time, start absorbing the information, go to tcpaworld.com, and Reach as well. What was the Reach website?
Yeah, so Reach it's Reach MBC. That's an M like Mariah. ReachMBC.com.
Okay. Some great resources. And if you're looking for more content like this, if you just type in YouTube Eric's name, you're going to find a bunch of webinars. And I will tell you, the more you hear it, the more it starts to make sense. And then you can apply those things in your business, obviously, or getting an attorney to help you do that as well. Thank you again so much for your time twice. I really appreciate it. And I know we're going to be making a bunch of changes at Accelerated Automation to make sure that our clients are better, well protected and informed. And the first thing we're going to do is make sure that they all subscribe to tcpaworld.com.
Well,
Thanks again.
Absolutely. Great to be here. Thanks.